Hello and welcome back to another video on my channel. Today I am going to be showing how I'm using Midpage to prepare for finals, specifically with my outlining. So what I'm going to do in this video is take a section of cases from my white collar crime class that all pertain to securities fraud, and then I'm going to create a notebook using them, ask a few questions, and take that material, these answers, to use to prepare for further outlining and further review of these cases. So without further ado, let's go ahead and I'm going to show you the notebook I've got. This is my current project. It is securities fraud. That is the section of the outline I hope to fill out today. And I have 4 cases from that, from my notes. And you can actually use the extract feature where you can, if the notebook had just been opened, you can click add cases, extract from text. It's this feature here, and so I could have pasted this and just have it extract for me. Now we've got that already done, and from there we are going to start asking some questions and really filling out what the takeaways are from these cases. But instead of doing it one at a time, we're going to do it all at the same time. And I think for finals preparation, this is where it is the most useful, especially for outlining purposes. So whether it's insider trading or mail wire fraud or securities fraud, I can take the 4 to 8 cases for each one of these sections, create a notebook on it. So the first question is going to be, what is the statutory language that the court has to interpret and apply to the facts of the case in determining whether securities fraud was committed? So let's go ahead and add a column here, and we can go ahead and say, yeah, we want any answer, not a yes, no. We're going to add that. While it's loading, let's go ahead and take the next question. What is the key takeaway? This is a little bit similar to my third question, but what is the key takeaway from the case and how does it affect future securities fraud analyses? And that question. And then lastly, I'm curious if this third question will give me a different response than the second one, and that is going to be for what propositions should I cite this case for on a law school exam regarding securities fraud. Let's add that. Let's go ahead and start reviewing some of these. Okay, so here we have the statute that is relevant for this case. Here we can have it take us straight to the court's discussion about it. So here is their rule statement. To prove a securities fraud in a civil action under Section 10b, the government must prove that in connection with the purchase of the sale or security of the defendant acting with scienter made a material misrepresentation. All right, so that's very helpful, and we can extract that and add it to our outline if we would like. Key takeaway, let's go to the next column. Okay, so now let's take a look at skilling. It says the key takeaway is puffery isn't a safe harbor. These executive opinions can be material when contrary to verifiable facts. So let's go ahead and look at the proposition for that. A reasonable jury could find that skilling statements were strongly contrary to verifiable historical facts. Accordingly, these statements were not immaterial as a matter of law. So that checks out. And again, this is one of the big advantages. If you are going through your cases trying to pull out these rule statements at this point in the semester for any class, you have essentially Midpage pinpointing where exactly in the case you should look to find that rule statement, and it's helping you check it. So let's go ahead and take a look at the last column for what proposition should I cite this case for on a law school exam. And here, this is kind of a different question because this isn't something you can find within the cases, but we're going to go ahead and see how it did anyways, even though it is a little bit more abstract. The notebook function typically is looking to the case for its answers. Materiality is objective, judged by reasonable investor, varying with market sophistication. Broker, dealers, and RMBs act as principals, no fiduciary duty in an arm's length transaction. Idiosyncratic erroneous beliefs are irrelevant to materiality. Admitting such evidence is prejudicial error. Great, so I love that it has given me a list of different things that I can cite this case for when I am writing on my law school exam. So it's not just like the Quimby, a singular one rule statement, especially with cases in white-collar crime where you get a lot of very rich discussions and takeaways from the court. So there is more than just one proposition, and that's one of the problems with studying with Quimby is you just get this one very general proposition. But here I think is where you have the opportunity to stand out as a law student and hit on more specific propositions. Alright, so for the last part of this video, I want to show off this feature where they allow you to download this notebook. So if you want to create a larger notebook over time with more cases and more, different sections than just one, like securities fraud here, well then I just want to show off this Excel. So if you click this, which I've already done, and it'll pull up an Excel sheet. Ultimately, I think this provides a great starting place for your outline. If you are someone who likes to break down specific cases on an individual level, then this is awesome. You can go ahead and have Midpage do the majority of the work here, and specifically the grunt work, pulling out things like the statutes that are being cited, and then you can come in later and you can type in or fill in more information that you think you want to add to your final outline, your final perfect outline that you're going to memorize before the day of the exam. So that's how I am studying in a more efficient and smarter way for finals this season, and I hope it was helpful. I hope you are able to use the same, and I hope you have the best of luck with your final exams.